Good. All right, welcome back to the House Judiciary Committee this Thursday morning, May 22nd, and we're going to it's a progress report, I think we can call it, on H 411 was the omnibus public safety bill that the administration brought to us. And we've kind of been, we've taken parts of that we were able to get the Senate to work on and that we worked on, and just want to walk through and see what we have left to continue to work on next year and see if I'm on the same page as you are as far as what we can take out of here
Sure.
Go back. So I'll turn it over to you, Jay. Thank you for being here.
Okay, thank you. Thank you for having me. And yeah, I'm hoping this is a little bit informal, but in more of a discussion, I'm happy to have. But yeah, so I can walk through it and we can see where we are. So from my perspective, and I don't know if I have all of this in the right order as far as the omnibus bill goes, but it might. Is the first thing we had asked for was repeal, raise the age for 19-year-old offenders, and then reform youthful offender to ensure accountability. So that's where we saw the two pieces working together. I mean, there's a question in my mind as to whether we really ever even needed raise the age. Now we have raised the age to 18, so that's irrelevant. But 19 and up is still a concern in terms of, while the brain is actually not fully developed, it's pretty developed. And so I think so there was one question there. We would still be pushing for repeal of raise the age. That obviously has been pushed off for 2 years. It gives us time to discuss that issue. The companion with that was this reform of youthful offender, where I think we really wanted to take a look at the way youthful offender used to work. And I think it was about the 2008 to 2018 or 19 timeframe, you had a system where 18 and 19-year-olds would be charged in criminal court. They could make a conditional plea of guilty, and then they could be moved into family court for all of the benefits of rehabilitation that the family court has to offer. And the beauty of that was accepting responsibility at the outset, right? They had to actually accept some responsibility for their actions. They had to be amenable to treatment before they could get moved into family court. And in family court, arguably, and again, this would be something for the committee to explore, you may have had some greater success with youth in that situation because they had a motivation to actually comply with the terms of their probation or their conditions of release or whatever it is that would happen in the family court. So I think we would like to take a hard look at that period of time. I think while many come in and say that the conditional plea is unconstitutional, we did have it for 10 years, and either it was challenged unsuccessfully or it was never challenged. But we did have that as a system for many years. Arguably, I mean, some would say it worked better. And it would be great to understand what people in the field are saying about that. So again, I think it really is more of a carrot and stick approach instead of a carrot, carrot, carrot approach with what we actually don't even know in the way of outcomes. We have no data on recidivism for youthful offender or for youthful offenders in family court and for raise the age offenders. We just don't have data. We don't know if it's working or not, and we don't think we are having great outcomes, or we might know that.
So before you move on from that one, just in the bill, section 21 is raise the age. I feel we've at least dealt with that for purposes of this section or for this bill in section 21 and 22 with H2. I know that there's still a desire to do repeal, and my focus is on trying to figure out how to have more accountability for that age group of 18 to 19. The youthful offenders is sections 23 to 30.
Mm-hmm.
I have talked to at least Tucker Jones that I want in the off session to continue discussion to address some of the concerns that we initially had, or just my discussion with legislative counsel. There were some places, but that's definitely an area I want to continue to work on as well. Is the youthful offender component.
Great. I think that's great. I think that, the idea that the committee is kind of trying to grapple with issues of accountability, I think is very helpful and maybe gives us a starting place.
Good morning.
Morning.
So we're still dealing with that raise the age thing and all that stuff, but we have plenty of juveniles below that age that are doing more and more horrendous crimes.
Yeah.
I don't even believe we still don't have a facility to really hold them or anything, and we're certainly not doing prosecution. Am I correct in that?
You're correct that we don't have a facility. You're correct that they would go automatically into family court for rehabilitative services. They would be subject to criminal prosecution in criminal court for the big 14 now. That's another part of our proposal that we made, I think, 2 years ago. We have made again in the omnibus, which is to expand that list of crimes. Because you're right, there are some very significant violent crimes, intimate partner violence, crimes against children that actually do get moved in automatically into family court. And it would be a good idea, I think, to relook at that larger list of crimes. We did it 2 years ago. It got pared down to, well, we lost one and got three. So I think that it is in the proposal that we expand that list of crimes so that there are more crimes that youth would be tried in criminal court for.
I guess what I'm trying to point out is the amount of grown-ups controlling people that are controlling the younger people to do the things that are not really above board, sex trafficking, the drugs, the fentanyl that's still coming in, all this stuff is somehow or another. How do we deal with that with such a young age? Because that's not in the top of the crimes. And I don't think we've addressed that at all.
It is, I think it was I think drug trafficking was one of the crimes that was moved up if you're over 16 and you can be tried in criminal court for drug trafficking. That was one of the big, now 14, but it's 16 and up, I believe. So we did address it to a certain extent, but I do think you're right that we have driven down the age of, I guess what you call drug mules, people coming into the state from out of state, because we have facilitated essentially the business model.
Thank you. So, and just those following along, it's that's section 17 to 20 in bill.
Is the larger list of.
It's the larger expanding list.
Okay, great, thank you. Then we did we wanted to continue to focus on the issue of repeat offenses in Vermont. Our initial, I think our priority there was bail revocation reform. I think in S1 or HS, 109, as it currently exists, includes the right to appeal a bail revocation denial. We would still like to see, which basically will toss the issue to the courts again. I mean, my view is when everybody looks at that SOV or SWAV case, however you pronounce it, is basically the court had an opportunity to determine that bail revocation was unconstitutional, and they did not do that. They essentially configured a test. It's not a great test or a clear test, but it is a test. And they had the opportunity to say that holding somebody without bail for a minor crime because of a bail violation, they had the opportunity to say it was unconstitutional. They did not do that. So you may have, when the 109 language, another opportunity to test the theory about whether it is unconstitutional. But what we tried to do in bail revocation reform, maybe not elegantly or successfully, but I think there is a way to articulate a standard that you could actually put forth in statute. It would, of course, be tested by the defense bar, right? That's their job. They defend their clients in court and they could test that theory. But I think that our concern is nobody uses bail revocation now because there's all this uncertainty. If we actually articulated a standard that we believe flows from the court test, we may have some success in using bail revocation as a tool.
Yeah, I mean, our thought on that, and I understand where you're coming from that, but I think at least my thought on that and what we put in S-109 is one way or another, the court's going to have to weigh in on this. And is part of the problem that the state's attorneys, this is kind of what I was hearing as part of the, was that they were not getting an opportunity to press this issue. It was not readily appealable when a bail revocation was denied by probably the more risk averse trial court.
Right.
So hoping to see how that plays out
Right.
before we start working on other definitions. But that's kind of just where we were.
Yeah, and that's clearly a multi-year project at that point. So we won't have any improvements in, I'm sorry, go ahead.
Yeah, go ahead. Yeah. No, please.
No.
Sure.
I mean, that's my concern is, we know that repeat offenses is a major issue now in our communities. This would be something we would like to see happen before the, 4 to 6 year litigation process plays out. So that would just be, this is a way to try and tackle that.
Yeah, we can continue to look at, I know that we did get some further suggested language from the Department of State's attorneys that
Yeah.
can take a look at. And I think it's in the context of 409 or 410 is that we have that separated out into that bill. But yeah.
I just wanted to say that I feel similarly about like trying to get language to kind of flow from SOB that would be a standard that could work. But I feel like what happened was we tried, and every time we got some language, it didn't seem like it was quite right.
Right.
But my only point would be the appealable language that we're giving state's attorneys would be for like an interlocutory appeal. So hopefully it would move faster than the 6 year, right? Like, because it'd be like a mid case. And so I don't know.
Right.
But,
Right. Possible.
Hopefully.
Yep.
Hopefully.
Okay. Yeah, I just would not hang my hat on that, but.
Yeah.
I think there's agreement that it's, at least I feel certainly that it's too strict what the standard is in the court. And it's too hard to get the bail revocation because you can have somebody doing something less than witness intimidation or destruction of evidence, and they are making it impossible to prosecute the case.
Yes.
Yeah. So I'm in agreement with that, but we couldn't quite figure out the language to get us there.
Yeah.
As far as the definition, and can we push it further by the state's attorney having a really good case on the facts that they can press it, so that's just been what I'm thinking of.
Yeah, sure. Yeah, I appreciate that. Then universal sealing of criminal records. We actually, I really appreciate the work that the House did on that bill. Representative Dolan did a great job presenting in Senate. Senate has quite a bit of division on their committee over this issue, to the point where 2 senators really had backed themselves all the way back into, we should just stick with expungement because if you don't have a record, you can't search a record. And so I think that we will see, I guess, what happens in conference committee at this point, and sincerely hope that S12 comes out of conference committee in some form or fashion.
I'm optimistic.
Right. Good. But yes, I think the House did a great job, we thought, and we really appreciated what you did with that bill. And hopefully that can be, the improved version or an improved version will come out of the conference committee. Yes.
Just clarifying, coming out of conference, leaning more towards sealing or back to expungement?
Oh, absolutely sealing. Yes. Yeah, the House had basically taken steps to remove the very complicated process to access records. And you had also taken out expungement for deferred sentences, which we feel very strongly was appropriate. We hope that the Senate loved the pieces with respect to notice that you added. So I think that the House version was well done and closer to our original proposal, and we appreciated the work that you did on that.
But the Senate's good too. Go ahead.
Yes.
But the Senate is not in agreement with us, and there's only 2 that kind of was, and now to get something, they're leaning going back to sealing? Did I hear
I
that?
think they're looking at it. There was a lot of strong feeling expressed about perhaps the status quo, keeping things the same. But there was also a sentiment that we move forward with something. I didn't see, honestly, I don't know exactly what they ended up doing after, what their markup was. But you will have to negotiate that in conference at this point.
Thank you.
And I don't believe it went back to expungement. Perhaps it did for purposes of deferred records. I honestly, and I apologize, I don't know. I just knew that it was going to conference, and that's for you all to work out.
Okay, thanks.
Yes, okay. Then limiting the authority of the court to suspend sentences for repeat violent offenses. This is something that definitely needs more work. When we proposed it, it was because we are seeing cases of repeat violent offenders who are getting deferred sentences, suspended sentences, reduced sentences. And it is just very, very frustrating to read a criminal record where a violent offender is repeatedly released on, essentially walks out the door of the courtroom, has a guilty, perhaps some sort of negotiated guilty plea, but never serves any time in prison, and until they are charged again with another violent crime. And it's really frustrating to read about. It's really frustrating to read the records. And so we wanted to take a crack at addressing that problem. It's clear to me now, and others, and the practitioners are the ones who need to speak to this, but basically, sometimes it's the only way to get a sentence. You might have a vulnerable victim who maybe lacks credibility. You may have a victim who won't show up in court at all because they're afraid. Many of these offenders are violent offenders, and they're very intimidating. And so they won't. And because of the complex relationship, particularly in domestic violence situations, just won't testify against the abuser. So sometimes it's the only way to get a sentence at all. And if it means that if they walk out the door and violate the terms of their release, they end up back in prison to serve their sentence. What's frustrating to read then is when they are then released again on a reduced sentence or some other procedural framework that we have in place, and they reoffend again, and the cycle continues. So I was hoping that there was a way to get at that problem, and it definitely requires more work.
So that's sections 4 through 6, I understand. And so just jumping ahead a little bit, we have the off session that we can continue to use we can use 411 as a vehicle.
Mhm.
And we can work on a version that takes out presumably the ceiling, because we'll have that passed, hopefully. Take out there's some other things in here we can take out.
Right.
But then it sounds like there's some additional work that needs to be done on some of these provisions as well. Is that something that what you just talked about as far as the sentencing is something that you folks are going to be working on a little bit more?
Yes, yeah, yeah.
Because I haven't mentioned that so much in talking to Tucker offline.
Yeah.
I've talked about the youthful offender, and I'm happy to participate on the youthful offender.
Okay, great. Yeah, I mean, it's something the governor feels very strongly about. I know that there are practical limitations, and so we'd like to understand, I think, what paths forward might exist. And again, particularly with respect to, I think we do a lot of dithering on domestic violence that kind of concerns me. And I think that we need to see if there are ways to keep people safer, actually safer, not just provide them with notice. I think you made some steps in that direction when, at least with the civil violation, people may be required to take some behavioral counseling. I think that there are things that we need to actually start to do better, rather than just things like notice or, committees who study the numbers of people dying. And I think we need to actually take some steps that may be more effective in addressing this problem, which is a growing problem, particularly with, in combination with substance use.
Thank you.
So So two things. One is it seemed like when the bill the governor just signed related to the DV fatalities, right? That
Mhm.
group is going to look at attempted murders too, which I think will get more at what, because it sounds like they do like a really comprehensive look at what systems failed and what could we have done differently. So maybe there will be a number of things that will need to happen, including changes to either the criminal law or procedures.
Yeah.
But Chair Lalonde had talked to us about looking at the cases of the people that have had the most charges, like and really trying to look into what their situation is. And I think a lot of that is what you were talking about a little earlier with the repeat offenses. I didn't raise my hand, but like and I think we were going to try to get some of the numbers from Tucker, right? And then I was going to try to
I think
dig
from,
into some of that.
Ken Wieners Dumont, they were gonna.
Right.
From the
Okay.
most outstanding dockets, those things.
Yeah,
Yeah.
and take a deeper dive on just understanding the situation. I mean, how many of them are, for instance, cycling through on findings of incompetency to stand trial? And
Yes.
I'm just trying to get a feel for, are there other places where we're not taking care of the problems earlier in outside of the criminal justice system? So
Right.
I think that's something we still,
Yeah.
And in the criminal, right, like,
and in the criminal justice.
because for a while, we've been saying, although people are like, how are you gonna say that? It's the backlog, and like, how much of it is the backlog? How much of it is people are waiting a year and a half to go to court, and so what the heck, why not? Nothing's happened to me so far, why don't I just keep doing what I'm doing?
Right.
So yeah, like I think it would be really interesting to try to dig into some of the case, and I don't know if there are ones that have hit your radar, or you're like, here's one of the ones that, in Burlington, the same couple of names come up a lot. So those would be good ones, but
And there are a lot of crimes of disorder. And those are obviously minor offenses. And they keep cycling through and, retail theft. But to the extent much of it is driven, say, by substance use or mental health issues or co-occurring disorders, I think we have made a lot of strides in those, in at least the area of mental health, crisis addressing, so crisis response, sort of the mental health urgent care. We've been trying to grow those systems around the state. But there's been a great reluctance in the legislature to address drug crimes and drug use because it's a matter of personal choice and it's a clinical issue and all those things, but it is affecting the quality of life in our communities. And at what point do we intervene? We made some proposals along those lines that your committee, for better or for worse, doesn't really see because they're in the healthcare area. But their issue, we proposed, and I think one that went to, at least there's a study, but one that went to, I guess, I don't know that you saw it, but it went to House Corrections and Institutions, is the idea of a DOC, a more extensive, the dedication of a DOC facility or entity in a DOC facility to do drug treatment and rehabilitation. So if you got a long-term sentence or a longer term, even not even long-term, 18 months,
Right.
So that you are effectively not just receiving medically assisted treatment, but you're receiving medications, you're getting the therapy and the behavioral therapy and connecting you with housing that's not in your former neighborhood, connecting you with jobs and skills, like that sort of more soup to nuts, keeping people out of the system.
And one thing that I've seen is most states, people are getting that the entire time they're in corrections, where our correction system, and I don't know if it's changed, but it was for some things you're getting it, but primarily we're going to do it in the last 6 months of your sentence. And that's not enough.
Right. And you're getting medically assisted treatment for the term that you're there or requested.
medically assisted treatment by itself is
Not
not
enough.
enough. It
That's
is
right. Yeah.
So
no,
where did that end up, by the way?
Well, it's a $200,000 study right now.
Okay, so, okay, the study, yeah, Zach, or I'm sorry, Tom, then Zach.
Yeah.
Sorry, Bob.
As long as we're on the subject, just an observation is, in my life, doing what I do, I don't think troubled people have really changed that much. We just have more of them. Seems to be getting away with more things. And, I'm grappling with trying to find a solution as well. What I'm seeing lately is when someone's picked up on what would be considered a lodgeable offense during the day, you would be required normally to bring it to court. There are prosecutors out there that don't want you to do that. They want you to call them first and see if it's appropriate to bring them to court. And they say no, kick them loose on a citation, which is, that's away from what our true legislative intent ever was. And at night, the same thing happens. They could put them in jail, but when they call for bail, and so you're essentially emboldening a person by letting them go after they've done something. There was no negative impact whatsoever. And I see a lot more to blame there than I do in the other. Just
Yeah.
throwing that out there, something else to consider. We have some philosophical issues within the prosecution.
And it would be great if the system worked in a way, because I think that some companion pieces that we had with that are this idea of a continuum of care. And it really is, it started with the inebriate beds, which is check. We did get that in S36. So, it starts with the inebriate beds, but a more robust system of community inebriate beds, where then you can connect people theoretically over a longer period of time with maybe the services that they need. Then in our treatment facilities, extending sort of, and I know AHS is working on this, Medicaid reimbursement for co-occurring disorders, Medicaid reimbursement for longer stays that are necessary. It's not just the 14 days for detox. It's a much longer period of time for the period of care that you need. And then they call them campuses, but they're really just facilities, treatment facilities for people who really do need a longer stay in order to, get the kinds of services that they need. So we did not get the campus. I think we did get some work and some assists from the legislature on reimbursement issues. And it is just a matter of, not just a matter, obviously, it's a very difficult issue because your brain is rewired, sort of how do you really keep people, how do you help people enough to get to a point where they are not reoffending? They don't have a need to steal just to maintain themselves and their drug habit, and it's.
I'm concerned with it, letting it get to the 15, 20, 30 reoffenses. That's what I'm seeing, and there's no need for that. And you're just kicking the can down the road and adding to the docket that we're trying to reduce. You're adding for dockets.
Right, and can you offer people?
Instead of dealing with it.
Right.
When it presents itself, we know we don't want to put people in jail, but you got to put the person in the environment where the prosecution and the defense can say, okay, they have a problem. What can we do about it? And get it going versus, well, let them go and we'll deal with it at their next court hearing. And in the interim, you got another victim.
Right. And I'm thinking that the way we were thinking of it and the care community, I know doesn't agree, but, and some might, is to the extent that you can actually frame it as a choice. You get, if we don't have the systems in place, we can't say, you can go to this facility or you can go to jail. Sometimes we can't say you can go to this facility because we don't have the facilities. But if we can build out a system where we do have the facilities and people can make a choice, or if you don't have a choice, but your only choice is prison, to be offering you the services that you need. So I think we're trying to set up a system where I think people are forced to, people don't, I know there's a lot of debate and discussion, and people who know more about it than I do are having those, but it's sort of this idea of, you can't make people choose, you can't make people seek treatment. but then you have this 35K docket person who's really, anyway, that's where I think that there's got to be a way that we can get at some of that. And maybe it is this choice notion.
Zach and Barbara.
It's a nice segue, Jay, because I think, we've talked about, the offenders and obviously the accountability function that, the governor and the administration is, keenly focused on, both in 411 and other pieces of legislation. I'm also reminded of a recent conversation I had earlier this week with Mayor Dungus of Rutland City. And, the topic came up of, how are, there's obviously the offender component, but there's also the people that are providing the substances that they're using. And so I'm curious about the administration's perspective and if there'd be an appetite for really, I think, a very forceful stance in legislation on holding drug traffickers accountable. Because it kind of seems like that's like, further up the pipeline in the funnel, but it feels like that's kind of the root of the problem where a lot of this, bad behavior and dangerous behavior is stemming from.
Right. Well, we've seen, so that's the thing. The governor used to talk about it as the four legs of the stool, and enforcement is absolutely one of those legs. And we have found that, say, like in communities like Springfield as an example, Springfield basically used to have a completely lawless block, really run by drug traffickers. There were lots of shootings. There was lots of, illegal activity. And at some point, VSP, working with federal partners, went in and basically did, sort of a drug task force mega raid, whatever they would call it, or however they would frame it, and essentially shut down the activity. And they had, there was lots of sort of fortuitous coincidences, but at the same time, they had just hired a new police chief who was very, very motivated to take on, to work with schools and hospitals and community members on housing and, work with the state police and others on enforcement. And Springfield is a really nice example of when all of the systems are working together. So you do have, and in our laws technically do provide accountability for drug traffickers, but we don't always, I think for drug crimes, you're just generally not seeing very long sentences. A lot of times in serious situations, we're trying to work with federal partners who will actually prosecute in federal court, because that's when they do get time. They're moved to federal facilities for incarceration. Those are serious cases, but the U.S. Attorney's Office won't handle every case. They won't handle small cases. They won't handle risky cases. So it's kind of the slam dunk cases and the big cases they will take. But it's unfortunate when you're thinking, well, the only way we're really going to get this guy is if we get him in federal court.
Yeah, no, true. And I think, I'm certainly not speaking for the mayor of Rutland City, but part of the premise of what he was suggesting is looking at mandatory minimum sentencing for drug crimes and kind of rethinking those, and obviously upping the ante on the state level.
Will definitely have to be a conversation taken up by the legislature. There's not a lot of appetite for it. We did get mandatory minimums last year, one mandatory minimum of 2 years for drugs death resulting. But it's drugs death resulting.
Yeah.
And so I think that is definitely something that the legislature would have to have some appetite for, because we have not seen that. But if somebody like Mayor Donges is bringing it, it may.
Yeah, I saw a draft of the bill that he's looking in some of the language. So
Yeah.
I would suspect that it probably is coming next session.
Yeah. And I want to be respectful of your time. I'm not sure.
So Barbara had a
So I just wanted to mention with your idea of people being able to have a choice. I know when I was at Lund, and I think this still is happening, since people could serve part of their sentence and go for treatment there as an alternative sentence, and it was a choice.
Yeah.
And it didn't have the same limited time parameters, which are so important because He said 14 days is not going to do it. So I don't know why that kind of model could not be expanded.
I'm thinking that it exists. I think that those things are happening now, and it would be great to understand more about it. I mean, from my perspective,
Right.
I mean, I feel like it would be great to understand more about those programs,
Yeah.
more about Tamarack. I mean, as far as I understand, the general view at the AG's office is Tamarack doesn't work because there's no services available. So if that is the problem, that's an AHS issue, and we got to work with the healthcare committees on what does that mean and how do we facilitate that? And then, of course, how do we fund it? But if it's a justice reinvestment kind of a concept where fewer people are in jail because fewer people are, offending because of their drug habits, then, maybe who knows how that all works out. But I think it's definitely worth exploring what's working.
I think it's costing the state a lot of money because we're not prosecuting enough for the crimes that are there. And I think maybe I'm wrong. You're the expert, but it does seem to me that we have repeat offenders many times over. And the reason for that is because we're not prosecuting. Am I wrong?
I think
I'm
that,
not talking just drugs, because
Yeah.
this whole conversation seems to be just going around drugs, and I realize that's a huge problem, but there's a lot more big problems. I think there's a lot of murders going on and a lot of other bad things that's going on, and it's getting worse, and it's gotten worse. And sure, we can go back to the COVID thing and all that stuff, but we're going further behind. I don't think we're going ahead. And this court case backlog, we're doing nothing because we're allowing these people to make these same characters to keep offending instead of holding accountability. How do we fix it?
well, so, so the thing about, a person with 35 dockets is being prosecuted, right? So prosecution theoretically isn't the answer. I think that part of it is court process, and the backlog is an element of that because there's obviously delay involved in all that. And like, the representative said, when people realize there are no consequences, there's, it's not hard to make the leap to, well, if they did it again, it wouldn't really matter. But I think that there's, and then there's necessity. People who are, if people are engaging in criminal activity to say support a drug habit, they're not going to just stop once they're released. It's not there's no incentive to seek treatment or anything. So, and that's not everything. And I think that part of it is court process. I mean, there's a lot of process, and what you often hear the prosecutors and probably even the defense bar say is people don't settle until a jury is picked, right? And there is a lot of time and motion practice in between the time a person is arraigned and a person ends up settling out their case. So you could do a lot of that faster if you had you had, I don't know, the AG's office dedicated 2 lawyers to sitting down with dedicated attorneys from the defense bar and hammering out misdemeanor crime settlement agreements, like just knocking them out. They've been sitting around. People come up with the idea every year of just wiping the state clean. I mean, that's not justice. But if you had maybe a dedicated court-like process for knocking out the misdemeanors in a quick way, but it would require dedicated resources. Statewide, the AG's office would probably be the most appropriate body for that. Barring that, the state's attorney's office would need dedicated resources for something like that. But you could there's nothing stopping you from doing something like that. It's just that nobody's forcing these settlements. And because the prosecutors have to focus on their major crimes, probably the biggest backlog is in the area of misdemeanor crimes. They're just sitting around.
One of the main objectives of the governor this year was public safety. Do you think we've we've done even near what he was looking for in keeping Vermont safe?
I think that over the last few years, we have definitely chipped away at the problem. We've passed some new crimes where those gaps have been raised. The signing today is an example of that, and which theoretically would increase accountability, also provide some closure for families who need it. And we have made some procedural changes that I think are necessary. And that's part of what we tried to do in 411 was address some procedural changes. I think that over the last, many years, lots and lots of procedural changes have been made to benefit defendants in, with respect to the process, making it harder to arrest, making it harder to prosecute, making it harder to convict, making it harder to incarcerate. And I think that you need a system that does all those things and to keep people, not to keep people safe. Prison is not the only answer, but I think that is certainly part of it. And that's why we've tried to chip away at it. And I think we've made some good progress, actually. It's not big or sexy, but it's good progress in terms of some changes to process. Could we make more progress there? Yes, we could. Ceiling will be a big one if we can get it. Something like bail revocation reform. It's hard to understand for most people. It's not it's not splashy or easy to explain, but it could make a significant difference if a person is repeatedly released on bail and their bail is never revoked. They just stay in the community. What's the point of bail? So they never show up in court.
Is that the judge's fault that they get released like that and they can keep reoffending? Or is that the lawmakers, which I'm one of them, that we're not doing our job?
I think there's a number of participants in the system, right? So judges who have the same offender with 35 dockets might do more to hold those people accountable by keeping them in jail until that they have actually attended their court proceedings. Like, to my mind, it's almost, I don't understand why the judiciary is not more concerned about respect for the integrity of the institution in those cases. I think they are concerned about it. And I think they are doing what they can with a system of 37 judges. But it does concern me, but I think that there is maybe more you could do with those kinds of dockets.
Do you think we need more judges? Or we need judges that hold people accountable?
We need more judges.
We do need more judges?
No, I don't think so. I mean, the number of judges has increased by at least 4 since 2017. And that backlog has only gotten dramatically worse. And that was about COVID, obviously, but it's been some time.
Thank you.
So just a couple of things. I mean, first of all, but also just will point out those things we're chipping away at is the resources that we've invested the last 2 years. And I thank the administration for going along with that, with the 3 judges that we added that have just started in January.
Yeah.
With additional prosecutors, defense, and it's going to take a bit, but hopefully we're starting to see the clearance rate change a little bit, and we're going to keep on looking for where else we can help to make that work, and including diverting more cases or continuing to divert cases pre-charge, and we really appreciate that there's investment in that as well. But as far as the bill, just 2 things that we didn't mention. The one was the extradition, and we did get that.
It's done, cross the finish line. Yay, congratulations.
And we have recidivism is in this definition. I don't think that's like the highest priority in here, although it's something that some people in here don't like me to use the word recidivism. They're tired of it already, but I'm going to keep on working on that definition, because the definition we have in statute right now doesn't make any sense at all.
Yeah, that would be great.
Yeah, so I think those are the last 2 things that you hadn't covered in 4.
Yeah, pretrial supervision. Actually, I don't know if we did expand the budget for that. I think that we had asked for it, and I just reviewed the budget.
That is a critical piece, and I know that we were very much in favor in here, but
Yeah. I'm not, it was not, there was no flag in the budget anyway, so I'm not sure. I don't know if DOC, I could talk to Nick about that. But anyway, we repealed the sunset on the public inebriation. Thank you for that. And then again, really the last prong, which isn't before this committee, is this whole idea of more effectively connecting addicted offenders to treatment and long-term recovery. I think that's an important piece. I know that Department of Mental Health is also starting to use some federal money, which God willing continues to be able to work more effectively with co-occurring disorders. The way our AHS system is set up, and we might want to think about this at some point. And I know, Martin, you've talked about that a little bit, Mr. Chair, sorry, about the idea of a Department of Public Safety in AHS for working with forensic cases. It's not always the easiest. AHS is a different kind of place because their job they're not thinking, there's no difference between a criminal person who's offending, a mentally ill person who's offending is a mentally ill person in need of care. Sometimes we need to, and in very obvious and gruesome cases, we need to do something more there. So it is kind of if that's a concept that's been kicked around, maybe worth discussing more. And that's all in that. But I do know, at least I think on the mental health is doing more with co-occurring disorders to the extent possible, given our structured system and the way that federal funding works.
Yeah, one of the things I was hoping to still get to this session, which probably not, because I'm hoping sessions very soon.
You never know.
No, jinx is competency, and that goes to what you were just saying. And I was gonna probably look at it in the context of competency restoration, not necessarily setting up a whole competency restoration system, because I know that's about a $5 million from a report that came out last fall.
Yeah.
But looking at ways that individuals who are found incompetent to stand trial aren't just left to their own devices, which seems to things fall through the cracks. So that is high on my priority list for next year as well. And so we'll probably hear more about that.
That'd be great. Yeah. I mean, there's one of the accountability is one of those issues, and putting some teeth in orders of non-hospitalization has been something that folks have struggled with for a long time.
Right, exactly. So.
All right, well, thank you. I appreciate it.
For the kind of end of session kind of report card here, what's our grade?
Oh, we don't have that, right? Do we have pass?
Pass fail.
What's our system? We don't have grades in Vermont.
Oh, that's right. We don't do grades.
Well, that's a full advantage.
So we put this pass fail.
Need a definition on that.
You want my answer, I'll get it to you.
Yeah.
No, I appreciate it. I think the committee's done some good work this year. I really want to thank you all for that. I think it's been nice working with you. It always is, but it's been an interesting session.
Yeah. Yes, it has. Yeah. Well, thank you very much again, Jake.
Sure. Thank you.
Sometimes you're too nice.
Nah, not the end of the session. Just deserve nice.
So we have nothing after the floor today, because I think it's going to be a little longer, and nothing actually on the agenda tomorrow. We have 105 on Tuesday afternoon, and we'll see if it might even be up for action on Tuesday morning. And obviously I will postpone action.
That's their reading today.
So if it passed third reading today, it'll be, we're having a token session on Saturday, so very possible that it could be actually up for action. So we could all come back in tomorrow and do 105 tomorrow if you want, or we can just postpone on Tuesday and plan on Tuesday afternoon looking at it. That sounds, all right, so we're adjourned until Tuesday.